8:52, time for tips. We're speaking today with Josh Winger from the law firm of Byrd and Byrd, LLC. Good morning, Josh. Welcome back.
Hi, Bill. Thanks for having me on the show.
Okay, talking about, last will and testament. Does that take care of all a person's assets when he or she passes away, Josh?
Well, Bill, unfortunately for many people, the answer is no. For the most part, the only assets to which a last will and testament applies are the assets for which the deceased person was the last living owner and for which there are no pay-on-death beneficiaries. But don't get me wrong, a last will and testament is a critical tool, and unfortunately only about 40% of people pass away with a last will and testament. Still, everyone should understand the role of a last will and testament in the greater context in a person's estate plan. There are three other ways, though, that an asset can be transferred at death, and each way of transferring assets at death have pros and cons for different people.
Okay, so what are the three other ways of transferring assets at death, Josh?
Sure. Well, the first is a very common but potentially dangerous way of transferring assets. It's to have a co-owner called a joint tenant with right of survivorship, or a tenant by the entirety. This is most common when spouses co-own a home or a bank account, where it can often be a good idea to co-own. However, a co-owner other than a spouse usually is a bad idea for a number of reasons. For this topic, in my experience, a typical example of adding a co-owner is when a parent goes to a bank to add a child to an account as an authorized user, and the bank misunderstands and instead adds the child as a co-owner. The result, due to the misunderstanding by the bank, is that when the parent dies, the co-owner child becomes the sole owner of the account, regardless of what that parent's will says. This clearly is not what the parent intended, but it is what will happen anyway and may frustrate that parent's estate plan. Second, many assets can have a designated transfer on death or pay on death beneficiary. Perhaps the most common example of this would be retirement accounts, IRAs, 401ks, TSPs, things like that, but also life insurance policies. The company or custodian through which you have the retirement account or life insurance policy give you the opportunity to designate direct beneficiaries for those assets. Even accounts such as checking accounts, savings accounts, money market, brokerage accounts, stocks, bonds, those can have pay-on-death beneficiaries. Third, assets, of course, can be distributed by various kinds of trusts. Now, there's a heck of a lot to say about that, but essentially there are revocable trusts and irrevocable trusts, and each serve different purposes.
Okay, for those of us that might not know, what is the difference between revocable and irrevocable trust, Josh?
Sure, yeah, that's a very common question. That's a very good question. Revocable trusts certainly are much more common, and they are always created while the asset owner, who's typically called the grantor, is alive. They generally are used for purposes such as avoiding probate, which is just the administration of a will through the Register of Wills, consolidating assets for simplified administration in the event of the grantor's disability or death, and, of course, tax planning in a lot of cases. Now, irrevocable trusts, by the very name, require the grantor to give up some right to the assets transferred to the trust. Typically, the right given up is to the principal, while the grantor retains the right to income. Now, irrevocable trusts are often used in situations such as Medicaid planning for long-term care or asset protection for business owners, and also special needs trusts. Now, in most cases, the grantor can also act as the trustee, who is the administrator of the trust. It's very important to remember that a trustee cannot act regarding an asset until the asset is retitled to that trustee, though.
I've heard that you can have a trust inside a last will and testament. Is that correct?
Yes, that is true. A trust inside a will is called a testamentary trust. Now, unlike the trust we were just discussing, a testamentary trust does not come into effect until the grantor dies and the will goes to probate. A testamentary trust can be used for probate and non-probate assets. Again, probate assets are assets governed by the will, and non-probate assets are assets not governed by the will. Now, for a testamentary trust to be used for a non-probate asset, the owner of the asset must designate the trustee of the testamentary trust to be the pay-on-death beneficiary with a custodian that manages the non-probate asset.
Okay, let's stop there for a second. What are some examples of when you might need to designate the trustee of a testamentary trust to be the pay-on-death beneficiary?
Well, trusts are often set up inside a person's will if there's a concern that the person inheriting would not be able to handle the inheritance. For example, a minor is under age 18 years old, but of course you can choose older ages as well. It could also be a child or an adult who has special needs, or an adult who simply does not handle money well. But however, as discussed before, oftentimes a person has assets like life insurance or a retirement account to which the will does not apply. So if you designate the underage or special needs person to inherit that life insurance or retirement account instead of designating that underage or special needs person's properly designed testamentary trust, that can cause a lot of problems, such as causing the special needs person to lose government benefits, or the court to create and monitor its own trust. There's a lot of problems.
Yeah, there's a lot to digest all at once. Hey, if any of our listeners have additional questions or want to learn more about estate planning, how do they get in touch with you?
Sure, yeah. We can be reached at 301-464-7448. Our Bowie office is located at 14300 Gallant Fox Lane, Suite 120, and zip code 20715. We also have a Prince Frederick office at 30 Industry Lane, zip code 20678. Those who are interested can contact us, and we'd be happy to discuss with them their specific estate planning needs. And we do understand that each person is different and has their own estate planning needs. Again, our phone number for both offices is 301-464-7448.
All right.
Thank you again for having me on the show, Bill.
Our pleasure. We'll be talking to you soon. That's Josh Winger from Byrd & Byrd, LLC, attorneys at law, lawyers with offices in Bowie and Prince Frederick, Maryland. Not just good lawyers, good counsel. Right now, we'll find out what's good in the newsroom. Barbara Cox back once again. Good morning, Barbara.